Next, we'll consider a letter requesting recusal submitted by Joe Kraft on behalf of Nicholas G. regarding docket number 24-27-T. Is there any discussion?
I'm guessing, since it's my letter, you want to hear from me. But I won't. I sent the letter as I would in any circumstance where a judge is presiding over a case and my client imparts information to me as Mr. G did. Mr. Dubos, with all due respect, I understand that you represented a co-defendant in the VA matter that is the subject of the disciplinary action before this commission. I also understand that my client reached out to you and asked for you to represent him in the same criminal matter and was told at the time he could not because of a conflict. I further understand when the state police matter came to light, Mr. G again reached out to your office to represent him in this case, as you were on the list for the PBA, the Police Benevolent Association, as counsel. He was told at that time, which I believe was sometime last year, that you could not again represent him because of a potential, or not a potential, because of a conflict of interest, because you had represented Terrence in the other matter. I did not know any of this when I filed the motion for summary disposition. I certainly did not know any of this when I was here arguing. My client watched the argument remotely as he was not here, because it's about 3.5 to 4 hours to drive here. Immediately following the hearing, he imparted this information to me, and I did as I would when any judge has a potential issue. I first sent what I consider to be an informal request for recusal on the basis that's set forth in Code of Civil Procedure Article 151. I had no idea this was even on the agenda this morning until late yesterday afternoon. Nobody bothered to let me know that this was a matter placed on the agenda, and frankly, my understanding of why we were here is because we have confected a binding settlement with state police of all issues involving Mr. G. That also, I believe, is on the agenda for this morning, as was the joint motion to continue the hearing or the trial on the disciplinary matter before you. That was denied, and I'm not sure why that was, because that is uniquely within the power of the executive director to grant it. But we're here. All these people are here. Drove in. We received an email from the executive director yesterday saying you better be here and be prepared for trial. But my request for recusal, as informal as it was, and not filed as a formal motion of recusal, as I'm empowered to do under the Code of Civil Procedure article, is in accordance with your rules, which is 13.23. The grounds for recusal of the commissioner or referee shall be the same as the grounds for the recusal of judges in the courts of the state of Louisiana. I follow the same thing that I have done in the past when I've had judges where there is a question of whether or not they fit within the ambit of recusal, i.e. I sent an informal letter. Apparently that's been escalated now to a matter on the agenda. But here's where we are. If this commission intends to follow the procedure for recusal, then I think it's first up to Mr. Dubos, as the judge, so to speak, to make a decision on whether or not he should in fact be recused. Thereafter, I don't know what y'all do. If it's a judge, generally speaking, what they'll do is refer the recusal to another judge to make that decision. But the easiest answer for today's purposes is the fact that the G matter is resolved. We have a signed binding settlement agreement, which I don't know if it's in your packets or not, but that resolves the issues, at least in my opinion. Furthermore, I'll point out, for the purposes of a recusal motion or request, under Louisiana Code of Civil Procedure, Article, I believe it is, no, I'm not putting my hands on it, but it specifically says that a judge may continue to preside on the matter until such time as he, or well, it says he, shall be formally recused. So that's the issue before you, however you choose to handle it. It was filed in all good faith and based on the evidence and information that I had then before me. That's all I can say about the issue.
Well, I believe that the commission's, at least my position on this, Ms. Kraft, is that we shouldn't take any motion or movement on this case until we address the recusal issue. That's why it's placed on the agenda prior to any other business. And the motion or the letter, albeit maybe a little bit improper, as it's not a motion, it is just a letter of recusal. I do believe it still needs to be addressed.
I don't know how you're going to do that. If you follow the Code of Civil Procedure, which is what your rules say, then either Mr. Dubos makes a decision on his own to recuse himself, or you guys have to refer it somewhere. I don't know how you do that procedurally, but That's up to you.
Well, let's look at the letter. I mean, you say it's an informal, but your letter, if you read it, says.
I wrote it,
"Please
Mr.
consider this letter," you might want to read it again, and let me talk, please. Please consider this a formal request for recusal of all members of the Louisiana State Police Commission. That's what you requested. It's a formal request to recuse the entire commission.
It goes
Now,
on to say, sir.
I'm talking. I'll let you speak, I'm gonna speak.
Mhm.
You went to great lengths at the first hearing to note that Mr. G was not a defendant in any case. He was not a co-defendant with my client. You said that he was going to be a co-defendant in that case. If you had read the affidavit, the indictment in that case, you would know my client was indicted for PPP loan fraud on a lawn care business. It had absolutely nothing to do with Nicholas G. He was never going to be a defendant in that case, or a co-defendant in that case, nor was he ever indicted, as you aptly pointed out numerous times. I have no record of Mr. G ever contacting my office. Your letter mentions that he contacted me to represent him in a criminal case. Now today you show up and you throw in that he allegedly contacted me to represent him in this matter, which is patently untrue. I've searched every email. I've searched every phone message. My secretary's done the same. We have no contact from Mr. G. If he's present today, I couldn't tell you who he is. I certainly never discuss any facts with any client or potential client on the phone. Mr. G did not contact me, to my recollection, knowledge, or record. And I absolutely never discussed anything about his case with him. And as far as my client, the man I represented, he was not a state police officer. He was completely unrelated to any matter before this commission. The indictment, the guilty plea, had nothing to do with anything that's relevant in this proceeding. Nothing. What my client did, he did on his own. Any action he took that may be similar to what Mr. G did or dissimilar was alone to my client and simply singular to him. Mr. G, whatever he claims, whatever is alleged he did or didn't do or should have done or should have done, is peculiar and particular to him. They were never defendants, they were never co-defendants. And I never undertook any representation of Mr. G. I never spoke to Mr. G to my knowledge, and certainly not about any facts in this case. And I discussed this matter with counsel before the hearing. We cleared there were no conflicts. And I stand by that I have no conflict. If I had a conflict, I would have recused myself. But I have no conflict. Mr. G, if this matter were to proceed, would be judged solely on his conduct, what he did or did not do. That's solely what Mr. G would be judged on. And he would get a fair and impartial hearing from me, and I presume from every other commissioner up here.
Mr. Dubos, this is not personal.
I don't take it personally.
I zealously represent a client. I don't tell you to stop talking and I don't cut you off. But I will tell you one thing, sir. If you're going to tell me that you did not represent Terrence Plaisance in connection with the Veterans Administration inquiry, that's certainly not what I understand. I understand your client pled guilty to a PPP charge,
That's
which
what you
was
attached
incidental,
to your letter.
which was incidental, sir, to what I believe was uncovered during the VA investigation. But if you want to tell this commission you were not at all involved in the VA investigation, then please do so.
No, I sat with my client during that investigation, and
Yes,
it's
sir.
solely to do with his conduct. It didn't have anything to do with Mr. G. They didn't interview my client, about his application. And I'm not going to go into any more detail than that, but you attached the indictment from the federal case, and you said that Mr. G, just a few moments ago, would have been a defendant in, quote, that case. He would not have been a defendant in that
The
case.
VA case, sir.
Well, you attached the indictment in the federal case in which I represented Mr. Blake.
I attached the plea.
No, you attached the plea, yeah, well, the indictment.
I
Yeah,
attached the plea.
okay, you attached something from that proceeding is my point.
I did.
And it had nothing to do with this case. It was completely, it couldn't be any more removed than apples to lug nuts.
Here's what I understand, Mr. DeVos. I understand that the same gentleman that my client hired to submit his application to the VA is the same one that your client hired to submit his application to the VA.
Okay.
I understand the guy engaged in the same cutting and pasting business, and I understand that the two cases were in fact related as they involved the same guy cutting and pasting the same information on the VA applications, which is what's before this commission.
And
Now, with
that's
respect to
the case
anything
tonight.
else, if we want to have a hearing, then you can testify, and I'll call my client to testify. I've made my statement. I represent somebody who had a serious issue with your sitting on this commission. Now, there's nothing improper about that. That is my job as an attorney to point it out as I did. That's my obligation as an attorney to point it out. It is not personal to you. It's not personal to this commission. But there is no way as an officer of any court or a zealous representative of my client that I could not say something about it. I can't.
Do you want to address the other allegations you made in your letter?
Which one, sir?
The other allegations you made?
Which ones?
The other than his alleged conduct law? You claim that I had actual knowledge and I couldn't have gotten from anywhere else. You said that I could have only known about the date that Mr. G.
Do we want a hearing to place you under oath, or place me under oath, and place Mr. G under oath, and his wife, who's a lawyer, under oath? We can certainly do that. But I'm not going to sit here and be peppered by questions. If you want to have a recusal hearing, then follow the code and let's have a recusal hearing now. If you don't, I've given you an out, which is that you may continue to preside until such time as there's a recusal. If the commission's preference is they're going to refer this matter to somebody else and let them decide, then we're going to have a hearing. But I'm not here to answer questions about it other than you asked me, it got placed on the agenda. I didn't even know it was on the agenda until yesterday afternoon. I've submitted my letter. I told you it was informal, not a formal motion, and I did that on purpose. Because I don't believe in filing formal motions unless I bring the information to somebody's attention.
So it's not a formal request for recusal?
I put it in my letter as that, yes sir, which I always do, before I file a motion.
Words have meaning, don't they? I mean,
Mr. DeVos, this is not personal. I understand you're upset,
No,
I get it,
I'm just trying to keep.
but I'm here as an
words you
objective
chose in your letter.
advocate.
What you said in your letter is now different than what you say today. So
No, it's not,
is
sir.
it formal like you stated, or is it informal like you now?
I have not filed a motion,
You
but
don't
I
have to
did
file
make a
motion.
request. I sure did. Because I had to. I represent a client who raised an issue.
Well,
Now, if you want to tell this
I
commission,
find I do not
you
have
did
to-
not represent Mr. Pleasant in connection with the same VA investigation that was involving my client and the same guy who cut and pasted on the application, then please do so. But that's not what I understand the truth
in
to be.
connection with an investigation into his conduct. I did not represent Mr. Pleasant into any investigation regarding Mr. G's conduct.
No, but you did with the VA, the same issue that we're here about on
I don't know if
Mr.
it was or wasn't. And Mr. Pleasant submitted what he submitted, he answered for that, and Mr. G submitted what he submitted, he can answer. Whether they were the same or dissimilar is irrelevant. They were separate applications
So I
submitted by separate
understand you've made your
individuals.
choice that you do not feel you should be recused.
Absolutely, I couldn't be more clear about that.
Okay, well, that's up to the commission how they wish to handle it. In so doing, sir, if you've made that decision not to recuse yourself, then the code requires you submit reasons in writing. However, what I have consistently stated to this commission and what the law says is you may continue to preside until such time as you are recused. That's the way the law works. But this is not anything personal to you, Mr.
I don't
DeVos.
think it personally.
I represent a client who has a legitimate concern about you presiding in this case. There is nothing improper about me raising that issue. I have to.
No one said there is.
That's your position.
That is my position.
Understood.
This commission is committed to ensuring fair and impartial proceedings upon review. There's no credible basis to conclude that Commissioner Dubos or all of the commissioners that you've requested to recuse themselves should do so, or have demonstrated bias or an inability to fairly adjudicate this matter. I would give you an opportunity to withdraw this letter of the recusal request if you choose.
Okay, first of all, it is not my obligation under the code to withdraw it.
I'm giving you
I
an opportunity.
understand,
I'm not
Mr.
saying- I'm
Malambo.
not saying that you're obligated to do so.
I understand. And so I guess from my perspective, if we're following the code, then we need to follow the code. And your rules, which require the recusal to be handled, I guess, in the same manner as it is under Louisiana Code of Civil Procedure Article 151. I have a good faith basis and did have a good faith basis for making the request based on the information I was provided. If you want evidence, I'm happy to put on the evidence. However, this again is not personal. It is my job as a lawyer who represents a client who has a legitimate question about a proceeding. And it was raised timely and it was raised immediately. However you guys have decided to handle this is amongst yourselves. But this is a public body, and public bodies are held to the same standards, if not higher, as anybody else. So I understand everybody's probably made up their mind, but I'm here to tell you, I'm not in a position to withdraw because that's not my job. That's you guys.
And we expect that all parties appearing before this commission to adhere to established procedures. and professional standards. And moving forward, we admonish against informal attempts to challenge the integrity of this commission and our proceeding through any correspondence other than formal motion. With that being said, this is not a formal motion of recusal. Agreed?
That's correct.
Any further discussion on this item? I'd accept the motion to enter an executive session. I move. So moved in a second, a roll call vote.
That's me. Mark Cole? Yes. Michael Dubos?
Yes.
Jim Kowalski?
Yes.
Ross Bushwan?
Yes.
Stephen Guidry?
Yes.
Jerry Ricky?
Yes.
Miles Michael.
Yes. And just to be clear, the basis for this executive session is for the discussion of the allegations within this item.
And so I'm clear, you don't want my client to testify as to what he knows? You haven't asked him to, but you certainly could.
Thank you. This is the
Thank you,
basis.
sir.
We're going into executive session now.
I consider your letter. Michael Dubos?
Here.
Jim Kowalski?
Yes.
Ross Bushwan?
Yes.
Stephen Guidry?
Yes.
Jerry Ricky?
Yes.
Miles Michael.
Yes.
We're out of executive session.
Ms. Krebs stated today that this is an informal letter and not a motion. By admission, it gives nothing for this body to consider or to vote on. And with that, we will move on to item number 3. The appeal hearing in the matter of Nicholas G., docket number 24-275-T. Representing Mr. G is Mr. Joe Kraft, and representing Officer of State Police, Mr. Joe Colbert.
Yes, Your Honor, thank you.
Please proceed.
Go ahead.
We have reached an agreement with Mr. G that we have submitted to you guys for consideration, and I can certainly read that into the record if you'd like.
Please.
In the agreement we have reached with Ms. Kraft, Mr. G's attorney, is that Master Trooper G's notice of termination is rescinded, and that Master Trooper G's here formally tenders his resignation effective retroactively to October 25th, 2024, which with all force and applicable retroactive to that date. And the state of Louisiana hereby accepts Master Trooper G's voluntary resignation effective October 25th, 2024, that he will irrevocably and has withdrawn his appeal of discipline regarding this docket number 24-275T, and that he will receive benefits back as documented in paragraph 6, to include a payout of his 31 hours of his 300 annual leave payout as if he had resigned, of $47.21 per hour, totaling $1,463.51. He will be restored 252 hours of 1.5 compensatory time and will be paid out in accordance with LSP Rule 11.29E, totaling $11,896.92. His unpaid annual leave of 1,930 hours will be restored into the LA Gov system, and it will be certified in accordance with 11.30A.
Other than the fact that my client,
Motion.
yeah, it's I move to approve the settlement, and furthermore, in accordance with the settlement agreement, my client withdraws his appeal. I think that's all I can say. You need to hear from him, but he did sign the actual documents. Thank you.
We have everything we need, and I'll accept the motion to go into executive session.
So,
So move. And a second. Roll call vote.
Mark Cole?
Yes.
Michael Dubos? Jim Kowalski?
Yes.
Ross Bourgeois?
yes.
Stephen Guidry? Yes. Jerry Reedy? Yes. Monty Montalinger?
Yes.
For an executive session.
Yes.
Michael Dubos?
Yes.
Jim Kowalski? Ross Bourgeois?
Yes.
Stephen Guidry?
Here.
Jerry Reedy? Yes. Monty Montalinger?
Yes.
Get back to regular session.
Any discussion or motions related to this matter?
Mr. Chairman, I'd like to make a motion that we accept and approve the joint settlement agreement for docket number 24-275-10.
Second.
We have a motion and a second. All in favor?
Aye.
Any opposed? The motion carries, and with that being said, there will be no trial. This hearing's been set since December 4th, 2024, but the commission didn't receive a joint motion to approve a settlement until 3:47 yesterday afternoon, well after the agenda was posted, the 24 hours prior to the meeting, as required by law. So with that being said, I would like to thank all of the witnesses who traveled in to attend this hearing. And at this time, I'll turn it over to the executive director for the director's